Good morning, you're Adam Moe? Okay, so we're here because Mr. Moe is on probation for I did a different type thing where Mr. Moe went and did some time on some of his cases in prison, got out and is now on probation. Apparently, there are some potential issues with regard to where he's living that weren't issues with parole, but are issues with probation. Is that correct?
It sounds like they may be issues with probation.
Okay.
That's kind of why our original emergency motion had a strange title, because we didn't know what else to call this.
Sure.
Other than in an effort to make sure that he is doing everything correctly. I think our mission on that was, let's get in front of the court and make sure this is being done correctly.
So what's the issue, potentially?
Adam's parents, Jody and Chris Moe, who the court may remember, and they're present again today, while Adam was incarcerated, went to a number of lengths with the folks from parole to make sure that any home that Adam was going to live in upon his release and beginning the out of prison portion of probation and parole, he's on parole too.
Correct.
That their home where he was going to live was in compliance.
Right. Parole's approved it.
Parole has approved it.
So where are we?
If the court doesn't mind, I'd rather not say the address.
No, I don't need that. I just need to know what the issue is with probation.
The issue is we are at 574 feet from a church that has a playground attached to it. And I don't want to speak for probation at all, but condition, I think it's 33. It isn't vague, but it's neither inclusive nor exhaustive. So I don't know exactly what the conversation was that probation had with Adam the day that he reported immediately upon his release from prison a couple weeks ago. And I don't believe that the conversation was, hey, you can't live there. It was, this is kind of an issue. So our position is a lot of effort was made.
So what's the issue?
Excuse me. So his condition number 33 says that he's not to be within 1,000 feet of places where children commonly gather.
Right.
So it's not limited to that list. And so I believe it's the 574 feet from the church with the playground attached is the issue.
Okay. I'm looking at the order now. Mr. Hoffpower, any strong feelings one way or the other?
Judge, we'll leave it to discretion of the court. I understand what probation is worried about.
Sure.
Set them up to fail. I do understand that's unique with parole and probation, two different entities, but
Well, and the
I don't want to
offenses
violate.
were possession of child pornography.
correct.
There weren't any allegations of
There were 10,
assaults or anything like
Correct.
that? Okay.
just 10 charges of possession. And 5, we put 5, got penitentiary and 5 with probation.
Right. Is there a GPS at this point?
No,
See, he hasn't had his initial, actually, the assignment is tomorrow. He just did intake and correct me if
Sure.
I'm wrong. He just did.
No, and I appreciate being proactive, and that is good. We don't want to be in here the first month because there's a violation, which technically that would be a violation. There's no doubt that it's not vague. That would for sure be a
No,
violation.
in my reading too on the geography of this thing, Judge, is that if Adam were to make, I'm going to call it a left turn if I've got the map correct in my head, if he were even to turn incorrectly down the main street where this house is, that would be a parole violation. So our position is that parole's assessment here, and I know the numbers are what they are, but that it covers both issues. So it's not like there's some kind of leeway to go even closer to that facility. He isn't going that way. He cannot, or he's in violation of what's been set up for with parole.
Judge, Ms. Roach says if he lived there, he'd be sentenced to his grandfather.
He's not, though. They specifically moved him.
Okay.
Meg, thank you, though.
Yes.
Ms. Roach is watching to make sure, because if you were living somewhere already, there's kind of a grandfathered in, but they specifically moved to try to make it better, and,
Yes, ma'am.
okay. Well, here's what I'll do. I will allow a modification of number 33. But I want it to somehow, some type of addendum or attachment that's very specific, because this isn't going to be a exception for all, only for this specific. So I will need probably the address of that church, so that in the orders, it says that you can be within 574 feet of that specific place. 33 stays the same for everywhere else. So it can be 33 can read like it does, and then you can add with the exception of that one place. Also, at least for, I would say, 6 months or so, or depending on how probation feels once he gets going, and if he's following all the rules and treatment and things like that with the LSOTP and all of that stuff, then I want a GPS monitoring device on at least for a minimum of 6 months to make sure that the rules are being followed, that he's going the right way, and there's not any issues. And that way, once we're all more comfortable with how things are going now that he's out of prison, then I'm okay with getting rid of that once you're okay with that, if he's following through with treatment and everything like that. Make sense? Okay?
Just one question. I think it's not the school.
It's not the school issue, it's just the church.
The church. Yeah, the church with the, so I want that, that's the only exception, and the exception is the 574. So like you said, turn the other way, don't get any closer than what you're saying. That way there won't be an issue with it being any closer than what you're saying at any times that it would show up on that GPS. Make sense? Okay?
Yes.
All right, thanks. Y'all are free to go. No, ma'am. Good morning, sir. You're Richard Robb?
Yes, ma'am.
And this is 24 DCCR 2170. You're charged with theft of property, and what is the announcement?
Your Honor, the state's offered felony deferred probation. We've countered with misdemeanor. I think the prosecution wants to review the file.
If the court would just give me a week or two, Judge, to determine if the restitution, if the item was returned, obviously the restitution will not be there. That's what our issue was, and then I'll offer that
right.
misdemeanor lesser included.
We'll reset it about 2 weeks.
Thank you, Judge.
Stay in touch with Mr. Kimmler, all right? And your bondsman, they'll let you know when you need to be back. We don't do that.
Oh, you don't?
Just
Okay,
stay.
go ahead and go. You don't need.
Sir, are you Juan Martinez Rodriguez?
Yes. Yes.
And Mr. Rodriguez, in cause number 25, DCCR 0017, you're charged with a third-degree felony offense of theft of property, and that's from September 12th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas, that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 5-year deferred probation, which means if you successfully complete that probation, you would not have a felony conviction on your record. You have every right to reject that offer. I just want to make sure that you understand what the possible consequences are if you're found guilty, and what your options are if you wanted to plead guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
All right, I'll get it set for trial. I want to also make sure, Mr. Rodriguez, that you understand that after today, I will not accept this plea agreement. Once your case is on the trial docket, if you change your mind, you can enter a plea to something different or go to trial and have a jury decide. You understand?
Yes.
And you're appointed, correct?
No.
Okay. All right, then Mr. Rojas will begin preparation for trial.
Thank you.
Thank you. And you also have Eliza Riley.
Yes, ma'am.
Eliza Riley. The way things are going this morning, I would have almost believed you. You're going to throw me off. All right, Ms. Eaglin, you tested negative. It is extremely important. That's a condition of your bond that you have that drug patch. So you need to make sure and do everything you can to get it, keep it every 2 weeks, get it changed. If you don't, it's a violation of your bond condition, and you could end up back in court. You could end up in jail for violating that, okay? So it's very important. So let me get this pulled up. Ms. Eaglin, in cause number 25 DCCR 0317, you're charged with assault of a peace officer. And that is from January 14th of 2025, and that's a second-degree felony. What that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? Speak up, please.
Yes, ma'am.
Okay, and then in cause number 25, DCCR 0318, you're charged with aggravated assault with a deadly weapon from January 14th of 2025. And that also means if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand? In each of these cases, I have here on the computer a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty in your cases, actually in one case. So the offer is to plead guilty in the assault on a peace officer for a 7-year deferred probation with a dismissal in the aggravated assault case. You have every right to reject that offer and have your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial?
Yes, ma'am.
And Mr. Nichols, is there any reason to believe that the offer would change? So I want to make sure you understand also that after today, I will not accept this plea agreement. Once the case goes on the trial docket, you can either plead guilty to something different, open to me, or we're going to let a jury decide, okay? All right, so I'm going to place your cases on the trial docket. Ms. Eaglin, Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Rojas, you are released. Ms. Eaglin, if you will just have a seat right over here in the courtroom, watch for the clerk to call you up. She's going to let you know who that attorney is today so that you can contact them and they'll begin preparation for trial. All right, thank you. Good morning.
Good morning, Your Honor.
Morning, Mr. Coleman. Good morning, sir. You're Zachary Turner. And this is 24 DCCR 2197. Mr. Turner's charged with fraudulent use or possession of identifying information. And what is the announcement?
Your Honor, we're needing a reset. I've talked to the prosecutor and we're needing some more evidence.
There appears to be maybe some videos that did not make it to our file.
Okay.
And thereby not turned over to the defense counsel. So I'd like some time to run it.
Sure. All right, so I'll just do a normal reset. Mr. Turner, make sure you stay in touch with Ms. Kaufman. Once she gets that information from Mr. Coleman, you guys can meet and go over it, and then we'll see if we can get an announcement at the next court date. All right, thank you. You're free to go. Thanks, Ms.
Thank you, Your
Kaufman.
Honor.
Ms. Pratt, why won't you give me your analysis this morning?
Well, that's the same thing we went through last time. That's why I have the patch, because I found out that I have a tumor in my kidney
Okay.
while I was in jail, so that's why I can't urinate.
Okay. Because I have notification,
The lady came from Vienna to put the patch on. It was real late at night in jail.
so I have notification dated yesterday, the 6th, that you got a drug patch on August 31st when you were in the jail, and that they haven't seen you back to change or put another patch on you.
2 weeks ago, they didn't tell me to come back. to try, they didn't give me a date or anything.
I don't believe
I
that.
thought I was coming today to get it taken off when I came, or yesterday.
That's not what I don't have, that's not true. So I'm going to
I
find,
had the paper at home. I didn't bring it with me.
well, you didn't show up yesterday, you didn't bring what you needed today, you haven't got your drug patch changed, you won't go to the restroom.
Well, she said 2 weeks.
Right.
When you change it.
Yeah,
Yeah, so it's been that right now. I was going over there when I left court. I was here yesterday. I was in the parking lot.
you being in the parking lot doesn't do any good because I'm not in the parking lot, am I?
Right?
Okay.
Yes.
Your criminal history is prior felony possession of controlled substance cases. The fact that I have notification that you have not changed the patch like you're supposed to, and that you, in my opinion, appear to be potentially under the influence of something this morning. For the record, it looked like you were sleeping, having trouble staying in your chair.
I've been up all night crying.
Okay, I'm going to raise your bond this time for violating your condition of your bond that you have a drug patch and have it changed every 2 weeks in the appropriate way. I'm going to raise your bond to $20,000. Condition of that bond obviously is that you have a drug patch. You got to figure out how to do it. You have to figure out, ask the questions, get it changed the right way at the right time, and then we'll see what happens from there. You can go back with the bailiff. Good morning. Are you Xavier Clayton? And Mr. Clayton was previously in court and entered a plea of guilty to the second-degree felony offense of assault on a peace officer. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
I have your own.
Any additions or corrections?
The only correction I would have is that he is remorseful for what happened. That's it.
Judge, of course, I'm aware that the court is probably hesitant to plead with the criminal history. The offer was made based on the fact that it dates back to 1995.
Right. Okay. All right, so, Mr. Clayton, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That includes that you're going to be on the high-medium caseload, at least for some amount of time. You will be required to begin a program for anger management within 60 days of the beginning of your probation, and to follow all of the other rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this felony conviction on your record. And if you successfully complete the probation, at the end, the case will be dismissed. You will not ever have this conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be found guilty of the offense, so you would have the conviction, and you could be sentenced anywhere in the range of punishment, which is a minimum 2 years up to 20 years in prison. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. And then it looks like there will be a dismissal in 24 DCCR 2206 as part of this, and I'll sign it as soon as it comes through. If you'll just have a seat here in the courtroom, sir, probation will call you up when she's ready to go over your paperwork, and so just watch for her to call your name, okay? All right, thank you. And then Sierra Jackson, Mr. Adams.
We reached a deal in that case.
Okay, I'll hold it while y'all do the paperwork.
Well, no, it's not gonna be.
Your Honor, what we agreed on is a dismissal for restitution. She's got to get the money, so.
Good morning. Good morning, sir. You're Donald Owens Jr. And Mr. Kelly, will your client waive the formal reading of the indictment?
We do.
Sorry, it's going a little slow. It's stopped spinning now. Oh, there, should Shut up. All right. Mr. Owens, in cause number 24, DCCR 1192, you're charged with the second-degree felony offense of sexual assault of a child from March 29th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because they you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kelly? And do you fully understand them? And my understanding is there is no plea bargain. This is just open to the court. Is that correct?
That's correct.
And that there is, in addition, not a waiver of the right to appeal because of that as well, correct?
That's correct.
And is that your understanding? That I want to make sure you understand, Mr. Owens, obviously you know your case is set for trial to begin with jury selection this afternoon. You have every right to have that jury determine if you're guilty and what your punishment is. If we go forward this way, you're pleading guilty and you're leaving your punishment up to me. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection, state's 1.
It's admitted. Is there any evidence that Mr. Owens is not competent?
There's not.
In addition to that, Mr. Owens, you do understand that as a condition of your plea in this case, that you will be required to register as a sex offender. And I have that document that you've signed with Mr. Kelly, and y'all went over that this morning, and you understand it. All right. Then I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. So for sentencing, since it's unagreed, do you guys anticipate lengthy hearings, witnesses? What type of time frame do we need?
Expect us to call witnesses, Your Honor.
Okay, any more than an hour's worth? Something we could do at the end of a docket? Or do y'all anticipate more
I
than
don't
that?
anticipate any more than that, Judge. We may have one witness,
Okay,
but I don't want to confine us to that. If it goes over, I only expect.
no, I mean, that's what I want to
Yes.
figure out, is if you anticipate that it could be longer than that, then I can set it on a date other than a Monday, when we don't have a trial or something like that. But if you
Yeah.
think y'all can get it in at the end of a docket from 11 to 12 or,
If the court can consider not putting it on a Monday, that's what we would ask for.
okay, all right, we'll take a look at appropriate date for that and let y'all know that court date. Obviously, anything you think is important for me to know, get that information to Mr. Kelly, and then I will look at all of that and listen to everything when we come back. All right, don't forget to stop and talk to probation. Thank you.
Your Honor.
Thank you, Judge.
This is yours, Ms. Malfino.
We filed a refusal on this, Your Honor.
Your Honor, Souls?
Yes, ma'am.
Mr. Souls, what made you think that wearing that kind of clothes or shorts to court would be appropriate?
I apologize, Your Honor. When I came this morning and I looked at the door, I never really paid attention to the door.
But even, how old are you?
I'm 38.
You're 38 years old. You've been in courts before.
Yes, ma'am.
Because you have felony convictions, right?
Yes, ma'am.
So have you ever been able, or it was okay to wear shorts in court?
Like my parents, Your Honor, Kathy Shoe, they allow us to wear shorts. And I was kind of rushing to get out here. So
That's
I packed-
interesting.
I packed my bag and I came to court. I apologize.
Okay, don't wear shorts again. That is not appropriate in here in felony court, you understand?
Yes.
Or in any court in Jefferson County.
In Texas.
Yes, sir.
So, Mr. Souls, in cause number 25, DCCR 0252, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from November 1st of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have a plea bargain rejection here on the tablet that has your signature on it with Mr. Kimler's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 4 years, which means you would leave your punishment up to me. I couldn't give you more than 4 years. I could give you 4, I could give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and let a jury decide. I just want to make sure you understand what your possible consequences are if you go to trial, what your options are. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get it set on the trial docket. You need to stay in touch with Mr. Kimler and your bondsman. They will let you know when you need to be back and ready for trial. Okay, you're free to go.
And if there's an
Good morning, you're Veronica Randall. And Ms. Randall, were you able to get an attorney hired?
Real expensive.
I'm sorry?
They kind of real expensive, but I talked to Sylvia, Brian, and Ryan, and I was working with them and see if I can come up with some of the money.
Mm-hmm.
And, you know, when I get my check and stuff, and Mr. Wilkinson also.
Okay. And are you working?
No, I get disability.
You do? So how much do you get a month?
I get like $9.50.
All right, so you do qualify for a court-appointed lawyer. Do you want to take advantage of that, or do you want some time to try to hire your own?
Can I take advantage of that?
She's already done a rejection, and I think she was injured when she did the rejection. No, and she got appointed and then she wanted out apparently. On it, the procedural.
Yeah, I do see that. Let me look at this.
I don't remember that was back in May, she did.
There was a did he withdraw? Let's see. Oh, that was just the, okay. So let's do this. We appointed. Let's just go ahead and put it back on it.
Yes, ma'am.
Yeah, all right. So if you'll step in front of the clerk, we'll put Mr. Vasquez, we'll leave him on your case, okay? She'll give you his information and let you know when to contact him. Step in front of the clerk, please. Good morning, sir. You're Bart Thibodeau?
Yes, ma'am.
And Mr. Thibodeau, did you get someone hired?
I got a bunch of these that I'm trying to hire, but they're way out there on price. I mean, my circumstances may be better later, but right now I can't afford the price of these.
Who'd you talk to? And these are okay if they're not on, so.
But I did get word in the hall that Mr. Wilkerson might be affordable, so I'll call him today.
And are you working?
I work for myself. I mean, work's been slammed to none since November. I mean,
Well, maybe you need to get another job other than working for yourself if there's no work out there since November and we're in August, September.
We're working, so my house goes $1,600 a month. I mean,
I understand, but if work's been slow since last November and we're almost in November again,
I work, but I mean, it's just slow.
okay, then go find something else to do. Okay, I appreciate that you did what I asked you. I'm gonna give you 30 more days. I want you to try, see if you can get some more work, find another job, bring me that information when you come back, and then we'll see at that point what your options are, okay?
Sounds good.
All right, step in front of the clerk, please. Daryl Albritton. Out today, so we need you to email it before everything gets closed out. Good morning, you're Linton Arsenault? And Mr. Arsenault, are you currently sick?
Ma'am?
Are you sick right now?
No.
Would you pull that down for me just so, there you go, I can hear you better in the hearing. And Mr. Arsenault, in cause number 24, DCCR 2190, was previously in court, entered a plea of guilty to failure to comply with sex offender registration requirements. The agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, Mr. LeBlanc, you may proceed.
Judge, reading this PSI report, it does appear that he has a lengthy criminal history. I would say the top part of that had a lot to do with him being homeless at the time. The criminal trespasses that were all dismissed, all those, it looks, Spence words, it looks worse than it, I've seen worse. Although he does have some extensive history. This case that he has to, the reason he has to report was from a case in 2023 that evidently he got the minimum 2 years, and I wasn't part of that case. He got the minimum on a, and I don't think he went to penitentiary. He stayed in county jail on that. That's my understanding, Judge. And I'm not making light.
On that case, he did, yes.
And in this case, Judge, I watched the video that he did go in and try to report. I don't think he went back the next year is what it was. I think he reported initially.
I brought everything in myself.
And I watched the interview, and it was confusing to me as to what he had to do. And I don't know. I think he probably just got frustrated and just didn't go the next year. And that's wrong. And that's what we're here before the court for. It's been capped, and I appreciate the prosecutor doing that. I would ask the court to sentencing towards the lower end, Judge. I don't think 10 years, 10 years is a long time for him not reporting for that. So Judge, I would ask that you consider, he doesn't want a trial, he doesn't want probation. He said that he was upfront with the court. Probation's not an option in his mind, and he's ready to do his time, whatever the court deems is fair.
All right, thank you. Mr.
I
Hoffpower?
want to direct the court to page 1 of the PSI, really it's page 2, but to the defendant's version, I don't believe that he's taking responsibility for it. He says, I think that's a hedge. That's not I did it, and he said he wasn't told somehow. He knew he had a report. He did, but he did initially, but then didn't. I'm not really sure what the court thinks of that. I know what I think of that is that it's a hedge, and that he thinks that he gets to decide whether he reports or he doesn't. I don't care how long he got initially. This is part of being a sex offender is reporting. We need to know where you're at, and if you aren't, then you're supervising yourself, and that's the problem. So the only reason I think the state and it's up to the court. Obviously, I don't agree with the lower end. I agree we have to know where he is, because if we rely on him to do it, he ain't gonna come. And he's not gonna report, so we need to do the maximum of 10 years that we will know where he's at for those 10 years. That's the only way we can be safe.
Thank you, Mr. Hoffpower. So, Mr. Arsenault, I noticed the same thing that Mr. Hoffpower did in your version when you talked to the probation officer. It says, I stopped going up there because when I went to court, the attorney told you were signing for 2 years, TDC. He didn't tell me anything about the registration part.
No,
You didn't say that?
no, ma'am. I did say that.
Okay, so when you were in court, I looked it up to make sure that we didn't miss something and that you weren't told about it. When you were in court with Mr. West, he went over with you the sex offender registration admonishment, and that's your signature right there, right?
Yes, ma'am.
Okay.
But he didn't explain nothing to me.
But you were told by him and by me that you had to register, and you obviously knew you had to register because you went and registered the first time. So saying you didn't know you had to register when you actually registered doesn't make much
I
sense.
went from Joe Stevenson. What is it?
No, you went and registered at the Beaumont Police Department. You went on July 20th of 2023 for your initial registration as a sex offender. So you did know you have to register because you went and did it. You just didn't do it after that.
Yes, ma'am.
Okay. All right, so I'm going to find that you entered your plea of guilty, and also, in addition to all of that, just so everybody's on the same page, this is your 8th felony offense. You have 7 prior felony offenses going back to 97, where you got a probation, got revoked, got 5 years in prison. You've been to state jail, looks like twice or 3 times. You went to prison again in 07, or actually that one ended up in 10 for 3 years. You went to prison in 16 for 4 years for an ag assault with a deadly weapon, and then you went for 2 years on that sexual assault case. So I'm going to find that you entered your plea of guilty freely and voluntarily. find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirement. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. LeBlanc. All right, good luck to you, sir. You can go back with the bailiff.